Who's entitled to an engagement ring in a New York divorce? Hi, I'm James Joseph, the managing partner of the Joseph Law Group PC. We're a Garden City, New York-based matrimonial and family law firm. This question comes up at least once a year in our practice. In the most typical scenario, the engagement ring was given prior to the date of marriage. If the parties marry and subsequently divorce, because the receiver of the ring had it prior to the date of marriage, it's considered their separate property, and he or she is entitled to keep it, and the other spouse has no claim to it. It gets a little more interesting when the parties never marry. If an engagement ring is given prior to the date of marriage, in New York, it's generally considered what we call a conditional gift. It's a gift, but the gift is conditioned upon the parties marrying. If the wedding is called off by either party, then the recipient of the ring can be required by a court to give it back to the person who gave it to her, to the person or him. The last scenario, which is really the most interesting scenario, is when the ring is given prior to the parties marrying, but the person who gave the ring wasn't in a place legally to be allowed to get married, meaning that they were already married to somebody else and they haven't divorced. New York doesn't recognize polygamous marriages, does not allow that. And so under those circumstances, a court would say it's not a conditional gift because you were not capable of being marrying at that point. And so if the parties never married, the person who received it would be allowed under most scenarios by a judge in New York to keep the ring. So kind of interesting, hoping that none of you need to know that information. But if you do, I hope it's helpful. And of course, as always, please discuss that with your attorney, the specifics of your case. Thanks so much.